A Terry stop is a brief investigative stop of an individual or a vehicle by a law enforcement officer. Another term for a Terry stop is investigative detention. A Terry stop is often accompanied by a pat-down or frisk to detect any weapons. For this reason, a Terry stop is also called a stop and frisk, although the stop and the frisk are legally separate events. The Terry stop is named after the 1968 U.S. Supreme Court case of Terry v. Ohio, which established guidelines for the use of stop and frisk procedures. Although a Terry stop isn't an arrest, Terry stops are subject to the Fourth Amendment's prohibition against unlawful searches and seizures. An officer may stop someone if the officer has a reasonable suspicion that the person has committed or is about to commit a crime. The officer's suspicion must be based on specific articulable facts that would lead a reasonable officer to suspect criminal activity. The officer can't rely merely on a feeling or a hunch. On the other hand, the officer doesn't need probable cause, which is a higher level of proof required for an arrest. Whether an officer had a reasonable suspicion of criminal activity will depend on the totality of the circumstances. For example, imagine that an officer was patrolling a neighborhood known for its high crime rate. The officer saw a person standing on the street corner with his hands in his pockets. The person's mere presence in the area probably isn't enough for reasonable suspicion. Now imagine that the person saw the officer and began nervously shuffling his feet, looking around, and obviously trying to appear casual. This is more likely to create reasonable suspicion. If the person spotted the officer and began sprinting in the opposite direction, then the officer almost certainly may follow and conduct a Terry stop. During a Terry stop, an officer may demand identification and ask reasonable questions, including questions unrelated to the reason for the stop. During a traffic stop, the officer may require the occupants to exit the vehicle. An officer also may arrest someone for failing to comply with reasonable instructions during a Terry stop. A Terry stop must be no longer and no more intrusive than reasonably necessary for the officer to confirm or dispel reasonable suspicion. Therefore, invasive searches or overlong detentions exceed the limits of a Terry stop and are likely to be treated as arrests instead. An arrest requires probable cause, which is a higher justification than the reasonable suspicion required for a Terry stop. In addition to investigating, an officer who conducts a Terry stop may sometimes perform a frisk. A frisk is a brief pat-down of a person to detect any weapons. To frisk someone, the officer must have a reasonable suspicion that the person is armed and dangerous. This may or may not be the same as the reasonable suspicion used to make the stop initially. Therefore, a frisk isn't automatically part of a Terry stop, but requires its own justification. For instance, assume that an officer made a proper Terry stop of a person wearing jeans and an untucked t-shirt. If the officer saw no indications of a weapon and didn't think the person was armed and dangerous, then he may not conduct a frisk. On the other hand, if the officer saw a pistol-shaped bulge beneath the shirt, then a frisk would be justified. The scope of the frisk must not exceed what is necessary to discover a weapon. This usually limits the officer to patting down the person's outer clothing. During a traffic stop, the officer may conduct a limited search of the vehicle's passenger compartment if the officer has a reasonable suspicion that the occupants might immediately gain control of weapons. A frisk is intended to ensure officer safety. Thus, an officer may not perform a frisk for the purpose of finding contraband or gathering evidence. Nonetheless, an officer doesn't have to ignore the obvious. If an officer conducting a frisk feels an object that is obviously a weapon or contraband, the officer may seize the object without a warrant. This is called the plain feel doctrine. However, the plain feel doctrine doesn't apply if the officer has to manipulate the object in any way to determine what it is. The plain sight doctrine similarly allows the officer to seize any weapons or contraband that come into the officer's plain view during a stop or subsequent frisk.